is held prior to jury selection, and this is after the case has already been through arraignment, discovery, pretrial motions, plea bargaining, and is now set to be tried by a jury. At this hearing, the judge will talk with the attorneys about trial scheduling, the number of jurors required, and it will also be a final opportunity for a plea bargain or even for the dismissal of charges or the changing of charges prior to going to trial next week. This is a big day for the defendants. They've been through from arrest, they're leading up to trial. This is where the rubber meets the road. Let's see what happens.
Where you were.
All right, so would you raise your right hand to be sworn, please? Do you swear affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? All right. What is your name, sir?
Christian Alexander Douglas.
All right.
I was just going to note to the court that I was just recently released from DOC October 31st, and I was out for 2.5 months doing good. I had a steady job. My point being is I don't feel that the court should see me a threat to society. I was just out there. Have a good job waiting on me. I'm just, trying to do the right thing here.
Your Honor, Ariana Leone for the state. First, I need to indicate to the court that obviously there is a victim involved in this case, and the state has attempted to notify the victim of this bond hearing to which he's entitled by right, constitutional right to participate, and we weren't able to locate him. Obviously, the defendant is entitled to a bond, obviously, on new charges. However, I would submit to the court that it would have to be a reasonable cash or professional bond, and reasonable wouldn't be $10,000 cash or professional. The evidence in the case is strong. We have independent witnesses. We were able to locate the weapon that was used, and it has been currently sent to FDLE for analysis. I would request at the very least, if this court is not inclined to grant a motion to continue this bond hearing for allowing the victim to participate and give his input as to what the bond should be, then I would request that the conditions would be house arrest, GPS monitor, pretrial services, heightened level, no contact with the victim, no trespass at victim's residence, and no contact with witnesses.
All right. Anything else, Mr. Gibbs?
Judge, I want the record to show that he was nodding his head when the state was requesting pretrial with a heightened level as well as a GPS monitor. He is amenable to that. And again, Judge, the main purpose of a bond, first and foremost, is, of course, to ensure his appearance in court. I have no reason to doubt that he would be active in his case and seeing it through to a resolution. In addition, again, I believe any failures to appear that he has are rather old. The most recent, I believe, was from 2019 or from 2019 or 2020. So it has been some time since he last allegedly failed to appear in court, and therefore I believe $10,000 is reasonable in this case. It does require that he put up some money. However, it makes it an amount that he can't afford.
All right. I think he is entitled to a bond under the law. I'm going to set a bond in the case. It's an attempted first-degree homicide, felony of the first degree, punishable by life. I'm going to set the bonding amount of $500,000, cash or professional only. Special conditions, he's not to be in the possession of or use any type of firearms or any other weapons. He'll also be on a active GPS, and he's not to have any contact or come within 1,000 feet of the alleged victim or the alleged victim's place of residence. And he'll obviously have to keep in contact with his attorney and make all court dates. All right, thank you. Yes, sir.
Is there any way that, because 500, that's a lot of money. Is there any way we could a little bit lower than that?
Nope, I've made my ruling, sir.
Yes, sir.
Thank you, Your Honor.
Are you
I
gonna come
have
see me?
someone with a medical issue that needs to get to an appointment. May go out of order. His name is Tyrone White. 22 CF 3181. Approaching. Your Honor, we are going to request a continuance on this case and ask to put it on the 424 docket.
No objection.
All right, without objection, I'll set it for April 24th at 9 a.m. for pretrial, May 1st, 9 a.m. Docket day, and May 8th, 9 a.m. for jury selection. You're Mr. White coming forward? All right, you don't need to come up any further than that, so I can see you're having a problem. Just need to be back in court those dates and times, and stay in touch with your attorney.
Thank you, Your Honor.
Yes, sir. All right, Ms. Dudley. Okay, you have,
Have a Kevin Johnson, Your Honor.
okay, Kevin Johnson, is that right?
Yes, sir. He's an inmate.
And this is a VLP hearing, is that right?
It's set for just a status, Your Honor. The docket does say evidentiary, but it says that after they go back to arraignment.
Okay.
Usually if it's at 1:30, it's a hearing. Larissa Dudley for Kevin Johnson and 20 CF 928. Your Honor, state has agreed to dismiss the violation of probation and terminate probation. He's completed all the requirements of probation.
Is that right? State's going to
Yes, Your
dismiss
Honor.
the charges of the VLP?
Yes, there is no objection to the dismissal of the VOP.
All right, well, state's dismissing it, so that takes care of it, sir. Here.
And probation is terminated, Your Honor?
When was
State
it?
would agree to that, Your Honor.
You're agreeing to that as well?
Yes.
All right, sir, the state's going to dismiss the VLP allegations against you, and they're also agreeable to terminating your probation, so that concludes this case.
Thank you, Your Honor.
You have any other cases?
That's all I have, Your Honor. Thank
All right, thank you. Mr. Keach, Jeremy Keach.
Morning, Your Honor. For the record, Jeremy Keach. First case on the docket would be State of Florida versus Donovan Smith, 22 CF 2441. I have a written offer of plea if I may approach the court.
Okay. Thank you. You have a score sheet?
It's a misdemeanor, Your
Misdemeanors,
Honor.
Your Honor.
Pardon me?
Misdemeanor, no
It's a
score
plea
sheet.
to lesser misdemeanor plea.
Oh, it's being reduced to a misdemeanor?
Yes, sir.
All right. Sir, would you raise your right hand to be sworn? Your right hand. Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And what's your name, sir?
Donovan Smith?
All right, Mr. Smith, your attorney's handed me a written plea agreement. It's dated today, has what purports to be your signature. Is that your signature?
Yes, sir.
Prior to signing this, did you read it?
I understand it, but I would briefly,
Well, did your attorney go over it with you?
yes, sir.
Do you have any questions concerning it this morning?
No, sir, not at this moment.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services, Mr. Keach, your attorney?
Very much, sir.
Has anybody forced, coerced, or threatened you to sign this,
No, sir.
sign this plea or to enter a plea this morning?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
Last night,
What'd you have last night?
I had about 3 beers.
3 beers?
Yes, sir.
And have the effect of those beers worn off by this morning, sir?
I would assume so, yes, sir.
Well, you assume so. I mean, I need to know whether or
Well,
not you're
I'm not,
under...
I'm not intoxicated, if that's what you mean.
No, I'm asking you if you're under the influence.
No, sir.
You don't have any effects of that beer at all?
No, sir.
All right. All right, I'm going to find then that and he's pleading nolle contendere, so the plea of nolle contendere to the lesser, or to the amended information, 2441, resisting arrest without violence, count 1, count 2, carrying concealed weapon is freely, voluntarily, intelligently entered. After the defendant's had the benefit of advice of counsel, the court will accept the plea, and he'll be adjudicated guilty on both counts. On count 1, he'll be sentenced, well, on both counts, he'll be sentenced to 11.29 months probation with the following special terms. strike that. On count one, he'll be sentenced to 11 months, 29 days probation. On count two, he'll be sentenced to 11 months, 29 days probation consecutive to count one. So that's basically just under 2 years. You understand that, sir?
Yes, sir.
Probation. Special terms and conditions, he'll be required to perform 50 hours community service work at the rate of no less than 5 hours per month. He'll be required to undergo a substance abuse evaluation and follow through with any treatment recommended with that evaluation, and he'll be required to pay fines and costs in the amount of $500 fine, $50 cost of prosecution fee, $100 legal assistance fee, and he'll be required to pay those monetary amounts during the course of his probation. Now, was there a requirement that he not be in the possession of or use alcohol or illegal drugs? I don't see it on here, but...
It wasn't a condition of the plea agreement, Your Honor.
That's correct, Your Honor.
All right, if it's not a condition, then I'm not going to impose it. But you will need to undergo a substance abuse evaluation, sir. That is a condition.
Yes,
You have
sir.
a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed on these charges. Good luck to you, sir.
Your Honor, due to Mr. Keats being appointed, we request the supervision fees be waived.
All right, I'll waive it.
Happy belated birthday. Go over and meet with Mr. Barry real quick.
Mr. Keats, you also have a James Terrell, is that right?
That's correct, Your Honor. If the court may recall, we scheduled him to come back today. This was a case where he indicated he wanted to proceed pro se, and you wanted to set it for today if we give him adequate time to consider that request.
Right. I think you told me you'd already had a Nelson hearing.
Correct.
So we're really dealing with a Feretta hearing.
And we just give him a minute. He needs a hearing aid.
All right. Morning, Mr. Terrell.
Morning, Your Honor.
Can you hear me okay?
Yes, sir.
All right, good. Sir, you were in court the other day, I believe it was Monday, if I'm not mistaken, and you told me that at that time you wanted to represent yourself, but then you seemed to equivocate on that, and I told you I was going to give you a couple days to think about it. Have you had some time to think about it, sir?
Yes, sir. No doubt. I'm scared to death over it, but I don't feel like I got a choice, sir, but to let my attorney go.
Well, it's already been determined that, your attorney is affording effective assistance of counsel, and, if you represent, sir, you have a right to represent yourself, and I recognize that. You have a constitutional right to represent yourself, but you also have a right to be represented by an attorney. The court has appointed an attorney for you, and right now he's still representing you, and he's prepared to continue to represent you. If you terminate his services and you represent yourself, you need to understand that you get no special treatment by the court or by the jail authorities. In other words, you don't get any additional library privileges or anything else. One of the biggest things that you need to be aware of is if you go to trial, and I think we talked about this being 2 life felonies, if I'm not mistaken. You're charged with 2 life felonies, and if you're convicted, you could be sentenced to life in prison consecutively. And one of the main things you need to be aware of is if you represent yourself, one of the issues you lose on appeal, if you're convicted, is you cannot claim ineffective assistance of counsel because you're representing yourself. Do you understand that?
Right.
Do you still want to represent yourself, or do you want to have Mr. Keach continue to represent you?
Mr. Keats, can you get me less than 10 years?
Well, sir, he can't guarantee that. The question, and in fact, I think I remember the other day, I thought that 10-year plea was
Off the table, yes.
was withdrawn by the state.
That's correct.
So at this point, unless there's another offer made, your option is to go to trial or to plead guilty or nolo contendere. Now, they may make another offer, before this case is concluded, but I can't tell you they will. I can tell you this, if they do make an offer, Mr. Keach is ethically bound to convey that to you, and I'm sure he would do that, but he can't guarantee they'll make an offer. They had one on the table, they've withdrawn it, so now the only option is trial or entering a plea. What makes you think you can represent yourself, sir?
Well, I think maybe I can deal with the DA to maybe get myself a better deal, sir.
They may not deal with you.
And they've got the charges trumped up, you know, to out, you know, that's wrong. And they're asking me to plead the charges that are trumped up and everything too, sir.
Well, I don't know anything about the facts of the case, but they're under no obligation, sir, to deal with you. You know, your attorney would be in a much better position to discuss the matter with the state and try to negotiate a lesser sentence if that's what you want to do. But they're in no obligation to negotiate with you. Have you ever represented yourself in court before?
I've never been arrested before, sir.
Okay. So from that, I take it you've never been involved in court proceedings. You don't know what the court procedures are.
Not at all, sir.
So you understand you don't get any break because you've never represented yourself in court before. You understand that as well?
Yes, sir.
You seem to be understanding me well enough, and you speak English, obviously. Do you write English? Do you read and write English language?
Yes, sir.
Okay. What do you want to do, Mr. Keach?
Keach, are you willing to help me do something better?
I think to perfect the record, you were extended an offer below what the statute would require, which would have been, if convicted as charged, which would be a minimum of 25 years. The state offered you 10 within a minimum of your charges. I can't promise you that the state would ever give you any better offer than what was offered previously. And at this time, because you revoked that or declined that offer on 2 occasions, that offer isn't even on the table. So I can't sit here in open court and promise you that you will ever get a better offer than 10 years, sir.
Mr. Terrell, what you want to do? You're going to have to make a decision.
Well, I can always reverse this though, right? If I make a decision today, I can always reverse my decision.
Well, the closer you get to trial, the more difficult that's going to be, sir. The closer you get to trial, the more difficult that's going to be. I can tell you this, I can't make the decision for you. It's your decision alone. But it's very foolhardy to try to represent yourself in a court of law in a jury trial where you have absolutely no prior experience in these matters. You don't have the ability to, and you're incarcerated, which makes it even more difficult because, as I said, you've got limited privileges that you're able to exercise at the jail. The sheriff is not obligated to give you any additional privileges. So what you want to do? Either want to represent yourself, sir, or Mr. Keach continues to represent you.
Try to go with Mr. Keach a little longer.
All right. I think that's a wise decision, sir. All right. Is this case, what's the next date this case is set for?
Judge, next pretrial will be fine.
It's not on the March docket. You want to set it for April?
What is that date, Your Honor?
April 24th would be the pretrial, May 1st docket day.
That'd be fine.
All right. We'll set it for the April 4th.
With the judge's name or?
Yes, sir. My name is Rasmussen. They'll give you that. Your pretrial conference is April 24th at 9 a.m., May 1st docket day, and May 8th jury selection, both at 9 a.m.
Your Honor, that concludes my business. Maybe excuse.
Thank you, sir.
Thank you.
Mr. Flaherty.
Morning, Your Honor.
Good morning.
I have one case on your docket this morning, State versus Mark Ramdas. We had originally been set for a bond hearing this morning. However, we've negotiated a plea that would resolve his cases. Yes. He has both a new charge as well as a violation. The new charge is 23 CF 443.
And Your
The
Honor,
vi-
the state filed an information this morning. I'm not sure if it's hit the clerk's.
What's the
site yet.
charge in that?
It's carrying a concealed firearm.
And then the violation of probation case is 2021 CF 1303. I did review the plea with Mr. Ramdas this morning. I read it to him out loud, and I also held it up so that he could read it, but he had to sign it here in court this morning. If I could approach?
Yes, sir. And you have a score sheet as well?
Yes, Your Honor.
Thank you. All right, Mr. Ramdas, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Was he adjudicated guilty on the first, on the 443?
No, Your Honor.
He was not. Okay. All right, Mr. Ramdas, your attorney's just handed me a written plea agreement. It's dated today, as your attorney indicated. Is this your signature, sir?
Yes, Your Honor.
And he indicated that he went over it with you in detail. Do you have any questions about it this morning?
No, Your Honor.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, Your Honor.
And are you satisfied with the services of your attorney?
Yes, Your Honor.
Has anybody forced, coerced, or threatened you to sign this written plea agreement?
No, Your Honor.
Have you had any drugs or alcohol within the last 24 hours?
No, Your Honor.
So what you tell me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes, Your Honor.
All right, the court's going to find then in case number 21 CF 1303, that's the violation of probation. He's admitting his violation, and I'll find that he has in fact violated his probation. I'll withhold the adjudication of guilt on the VOP and also the underlying offense. In case number 23 CF 443, the new law violation, carrying a concealed weapon, which was an unlicensed firearm, the court will also accept that plea, finding it to be freely, voluntarily, intelligently entered, and withhold the adjudication of guilt on that one as well. And on 23 CF 443, he'll be placed on 12 months community control with the following special terms and conditions. He'll be required to pay $515 court cost, $100 cost of prosecution, 10 hours community service work at the rate of no less than 2 hours per month. He'll be required to obtain or make a good faith effort in obtaining a concealed carry license. It's actually in FAR, a concealed carry weapon license. And he doesn't have any prior felonies, is what you're telling me.
No prior adjudications, Your Honor.
Okay. And on the, and I'm going to waive the cost of supervision on the community control. On the VOP, he'll be sentenced to 30 days in the county jail. He'll get credit for time served. And the violation of probation, once he serves that 30 days, will be revoked and terminated. And any outstanding monetary obligations in that case will be reduced to a judgment lien. And this is a uncoerced negotiated plea agreement, so the court will indicate that. So right now, the guidelines provided for you to obtain a minimum state prison sentence, about 12.75 months, because you entered this plea agreement that you won't serve that on this case. However, if you're in possession of another firearm, sir, or you violate your community control in any way whatsoever, that sentence goes up, and you can expect to go to state prison if you violate. You understand that?
Yes, Your Honor.
You have a right to appeal the sentence to the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal.
Thank you, Your Honor. That's all we have.
Okay, thank you, sir.
Sit right over here. Oh, Mark, I'm sorry.
That was all the private attorneys that were here, I believe. Oh, Mr. Tony. You didn't sign the list, so
I didn't get here in time.
okay. Who have you got?
Judge, today I have Ms. Ebony Williams. She's currently being represented by the Public Defender's Office. And I think we provided a substitution of counsel that has not been entered. Ms. Williams, will you please approach the well?
Your Honor, this was also set on the docket today for a motion for fingerprint exemplars. The order's already been signed. We just have someone from Crestview Police Department.
This
here.
is one that we did the other day from Crestview Police Department was supposed to be here?
Yes, Your Honor, and someone is here to take those prints today.
Okay.
And we are still in trial posture, at least according to the state. I know Mr. Tony just got on the case.
Yes, and I'm requesting a continuance. Need one more continuance, Your Honor.
State would object.
All right. And what is her name?
Her name is Miss Ebony Williams.
Williams.
Yes, and that's case number 2021 CF 2987 and 2021 CF 2986.
All right. Right now, she's represented by Miss Rivers. Is that right?
That's correct, Your Honor.
You going to substitute?
I have a substitution.
Oh, you have one. Okay.
We'll
Have I already
be following
signed?
that.
Has the order already been signed?
No, Your Honor.
You want me to sign it?
Well, it's not an order with it. We'll just submit an order to Your Honor a little later.
Okay. All right. What do you want to do? Continue it to the April?
Yes, sir, Your Honor.
All right. That would be April 24th, pretrial, 9 o'clock. May 1st, docket day. May 8th, jury selection, both at 9 o'clock. Ma'am, you need to stay in touch with your attorney. You need to be back in court those dates and times. That's a condition of your bond. And apparently you need, there's somebody here from
Police Department. Your Honor, may he approach and roll her prints
Right.
on behalf of Crestview Police
You
Department?
need to be fingerprinted this morning from someone from the Crestview Police Department, ma'am.
Yes, Your Honor.
Okay. They'll do that now, and then once that's done, you're free to leave.
Thank
Okay,
you.
good luck to you. What about Mr. Lupellis? There he is. Okay. You have Diana Chambers.
Ms. Chambers, before the court on 19 CF 1701. This is a motion to early terminate probation. I don't know if the state's objecting at this time, but we're prepared to proceed.
Your Honor, if I may, I just need to confirm with probation that she has completed all the requirements, and if so, the state will not object to early termination.
That's fine. We
I'm
can.
sorry, can you give me her name one more time?
Diana Chambers.
Number 15.
That's correct, Your Honor.
So she's satisfactorily completed all the terms and conditions of the probation?
Yes.
Sir.
Oh,
Per the notes I have on my paper.
All right, ma'am, your attorneys filed a motion to terminate your probation. The state apparently has no objection since you satisfied the terms and conditions. Based upon that, the court will grant the motion. Your probation is terminated and revoked. And I'll also congratulate you, ma'am, on successfully completing the probationary sentence. Good luck to you.
Your Honor, can I address one other thing on this case? There was a Scrivener's error in the adjudication portion of the case from our last hearing. The adjudication of guilt should be withheld, and I think it showed on the clerk's site that said adjudication delinquent, which I think is a Scrivener's error. I have the clerk's printout. Okay, and then I believe on Judge Flowers' order, it says adjudication. That's probably where they got it from. That was a mistake on that order. So there may need to be a subsequent order entered if it's deemed necessary. But if the clerk is okay with it being corrected, and it's reflected so in the record, I'm fine with that. Okay, very well, that's all I have.
As long as it was just a scrivener's error, there's no objection. I have no objection getting it corrected.
Thank you, Judge, that's all I have.
All right, thank you, sir.
And Judge, could I approach just briefly?
Yes, sir.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
All right, Miss Flowers, is she here? Okay.
Yes, good morning, Your Honor.
Good morning. You've got a Gloria Pettit, is that right?
I'm supposed to have a Gloria Pettit to address her capias status. She does not appear to be here, Your Honor.
Gloria Pettit. No response, and she wasn't here earlier?
I think there's already a capias with no bond issue.
And I was confused as to why we were going to ask to withdraw her capiases today because there was some confusion back and forth of court dates, but I wasn't sure why she was on today's docket, but.
If this is the one I was thinking from Monday, you said there might have been some confusion about that, and a capias was issued, and I think I issued another capias for today, but said if she came in today, I'd go ahead and address both of them.
Right, and she does not appear to be here.
Leave both capiases outstanding then?
Yes, Your Honor.
No bond pending first appearance. James Simmons, you also have Mr. Simmons, is that right?
I believe Mr. Simmons is ready to. We're here today. Mr. Simmons entered a plea in court about a week ago. He pled no contest to his charge in 22 CF 2586 and was sentenced to 2 years of community control. However, he since realized that the community control is just not feasible for him, and the state is agreeable to modify his sentence to allow him to do 6 months in the county jail. So I was writing it up. Do I need to do an amended plea and sentencing agreement, or can we just announce that? Or,
What would Madam Clerk prefer? Or it's really a motion to modify sentence that's unobjected to by the state.
We're just it's a stipulated modification of his sentence from community control to 6 months Okaloosa County Jail. The same, the 515, the same, all the court costs the same, 515 court costs, $150 cost of defense. Those we would ask to. An adjudication of guilt, and we would ask for, do you want 180 days to pay after you get out? Or do you want him to send? If we would ask the court for 180 days for him to pay the court costs upon his release, and then to collections.
All right. Mr. Simmons, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, sir, do you understand what your attorney is saying? That,
Not technically, Your Honor, I do not.
Okay,
I
well, let
cannot
me-
read and write at all.
okay, well, let me explain as I understand it.
Okay.
Apparently, one day last week or a week before, you entered a plea to the charge of petty theft as a third or subsequent conviction, and you were sentenced to 2 years community control with special conditions.
Yes.
And community control is difficult to do, and apparently you're not able, you've recognized you're not able to do it.
Your Honor, I was on duty community control. I was put to his office and
You don't-
transferred to Santa Rosa County until my officer over there told me the first day he laid eyes on me, when I said yes, sir, to him, call your lawyer and get you back in front of the judge. He was gonna violate me right then.
Because, what, you don't have a residence or a...
The residence that I had, I worked for my cousin, and this man, Mr. Barry, knows my cousin. You can't work under the table, you can't do this, you can't do that. It's the best thing you didn't do is go to prison or go somewhere else, not here. That's being railroaded to me. That's the way I've seen it, Your Honor.
And Your Honor, I've explained to him more than, I've talked to you about, do you not want to do this? Because we can do the other option, if that's,
I'll leave it to the judge.
Well, it's not my decision, sir. You know, I can't force you to take, you've already been sentenced to one
Yes.
sentence. And without a modification, that's your sentence. And, you know, you can leave here today and start your community control, but from what I'm hearing you're saying, that the likelihood of you being violated on community control is very high. But I guess, you know, you're going to have to make a decision as to whether or not you want to comply with the terms and conditions of the community control, or whether or not you're willing to consent to doing a period of time in the county jail.
Your Honor, if I may, I wasn't privy to Mr. Simmons and his probation officer's conversation. However, I know Mr. Simmons, and when he told me that he wanted to work with his cousin and it was under the table and he was going to be moving about town doing scrapping work or junk work or stuff like that, it just wasn't going to be a good idea for him on community control. And we can't allow them to do it if they're not being taxed for it. And then he found out he lives in Santa Rosa County, so I muddied the waters further. I said, hey, we're going to have to transfer you to Santa Rosa County. You're going to have to report to Milton. With not having transportation and all the things that he was getting into, I went out to a residence here that we let him stay out temporarily. He said they offered it 9 months. I told Ms. Flowers, I told James, I said, hey, look, if you come back to court, we'll see if we can't get it down to 6 months. James was amenable. Ms. Flowers worked her magic, and here we are. I thought it was a done deal. I don't want to see him go to prison, but I don't think he can successfully complete community control.
If he violates a community control guidelines, is it a state prison sentence?
it's not, I don't think he scores prison, but.
I don't think so.
It'd be more than 6 months county jail, I'm sure.
He qualifies for prison. He scores over 22 points, but he doesn't score a guideline sentence.
All right. What do you want to do then, Mr. Pettit? Do you want to, I'm sorry.
I was supposed to hold on a minute, Your Honor.
Yeah. Mr. Simmons, what do you want to do?
6 months is a little high on me, Your Honor, but I was seeing if the state would go a little lower on the
Well,
sentence.
That's the,
They made an offer, and I
That's the
guess
offer.
that you've got to decide whether or not you want to accept it or leave and try to complete the community control.
Take the 6 months, Your Honor.
All right. Then procedurally, I think the way to do it, Ms. Flowers, you'd have to file an or tennis motion to modify the sentence.
yes, Your Honor, I would move to modify the sentence on behalf of Mr. Simmons. I would move the stipulated motion to modify the sentence to 6 months jail in case number 22 CF 2586.
No objection.
All right, I'll go ahead and allow that. and the prior sentence will be vacated, and Mr. Simmons will be sentenced to 180 days in the county jail. He'll get credit for any time served. The outstanding fines and costs that were previously imposed will be reduced to a lien that will accrue interest at the legal rate. So you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, want to be appointed, you have 30 days from today to file your notice of appeal. And I'm sentencing you to county jail, so you will be adjudicated guilty, and you'll need to be fingerprinted.
Do I get credit time served for what I've already done on all this?
What now?
Do I get credit time served for what I already done on this?
Yeah, you're going to get credit for time served. From the date of your arrest on this offense, sir, you'll get credit for that.
Thank you, sir.
All right, good luck to you, sir.
Take care.
Brenda Snell, that's also you. Okay, Brenda Snell, is that
Yes,
yours?
Your Honor. Your Honor, this is Brenda Gail Snell. We're here today in case number 22 CF 1084, 22 CF 1309. Jennifer Flowers on her behalf. For the record, we're here on a motion to set bond. Your Honor, I've filed a motion with the court. I don't know if the court's had a chance to review it, but the defendant was entered into a plea agreement in these cases back in October. She was arrested on January 30th for a new law violation. That case number is 23 CF 283. She was given no bond on the VOP at first appearances. Your Honor, the defendant's husband is ill and she's basically his caretaker, and they live here locally. They have for 57 years, she says, and we're requesting that the court set a reasonable bond on the VOP. She has expressed interest in drug court. We're going to have her evaluated for drug court. So today we're just asking the court to set a bond.
Your Honor, the state's objecting. She does have some pretty serious priors in her history. She scores 14.85 months DOC. She does have a prior robbery, sudden snatching. She has felony batteries, fraudulent use of credit cards, DUI, several other miscellaneous misdemeanors, and crimes of dishonesty felonies. She was out on 2 cases on probation when she picked up this new law offense. The state's objecting. She's not entitled to bond on her VOP. Bonds remain as is.
All right. Looks like she was placed on probation on October 24th of 2022, and then within 3 months, she's got another violation for another drug charge, 2 drug charges, 2 possessions. I'm going to deny the motion for set of bond. She'll remain in jail pending final resolution of the cases.
Thank you, Your Honor.
Amanda Gail Wheeler.
Motion to continue.
Yes, please. Thank you. Thank you. Okay, Your Honor, this is Amanda Wheeler. We're here today in case number 19 CF 1310. We were set for a motion for bond, but I'm going to withdraw that orally, and we've entered into a plea agreement with the state addressing the VOP and her new law case, which isn't on the docket. The case number is 23 CF 224, but she's going to enter into a plea for a global resolution. And I have the plea agreement, may I approach?
Yes, ma'am. Ms. Wheeler, would you raise your right hand to be sworn, please? Do you swear affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And you're Amanda Wheeler?
Yes, sir.
And Ms. Wheeler, your attorney's just handed me a written plea agreement dated today. Has what purports to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you go over with your attorney?
Yes, sir.
Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney?
Yes, sir.
And are you satisfied with the services of Ms. Flowers, your attorney?
I am, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will, is that right?
Yes, sir.
All right, the court's going to find that the plea of nolo contendere, case number 19 CF 1310, that's a violation of probation on a, looks like a first-degree misdemeanor. She'll be adjudicated guilty. I'm going to revoke and terminate her probation. She'll get credit for time served. And she'll be required to pay a $100 VOP fee and a $100 cost of defense. And that case will be concluded. In case number 23 CF 224, you'll be adjudicated guilty, placed on community control for a period of 12 months with the following special terms and conditions. That community control will be followed by 2 years probation. Over the terms of the probation and community control, you'll be required to pay $515 court cost, $100 cost of prosecution, $150 cost of defense. I'm going to waive the cost of supervision. You'll be required to undergo and successfully complete a substance abuse evaluation and follow through with any recommendations from that evaluation. And I want to get that evaluation to be done within the first 30 days of her community control, if it can be scheduled. If not, as soon as possible thereafter.
Yes, sir.
She'll undergo random urinalysis. And here again, it doesn't say that she's not to be in possession of or use illegal drugs or controlled substances. But you understand, ma'am, that's
Yes, sir.
That's obviously a condition of your probation, because if they're illegal, you can't be in possession of it. What about alcohol? Was that an issue on this one? Okay.
We could,
All right, well, she's not to be in possession of or use any illegal drugs or controlled substances without a valid doctor's prescription. It goes without saying, as I indicated, but I
Yes,
just
sir.
want to announce it so she understands
Yes,
that.
sir.
Ma'am, you have a right to appeal the legality sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. And you will need to be fingerprinted on these charges, and this is a guideline sentence, it looks like. No, it's not.
It's a downward
It's a
departure,
downward
Your
departure
Honor.
based on a legitimate, uncoerced plea agreement.
Yes.
Okay.
I believe that's all I have on the docket, Your Honor. Maybe
Yes, ma'am.
I need to talk to that one first, please.
Wellington.
I think Ms. Rivers can go.
David Wellington. Yeah, we can do that one. David Oscar Wellington.
Your Honor, Mr. Wellington's attorney is from out of county. He emailed me this morning and indicated that he filed a motion to continue. We're still working on getting all of his credit added up. He was in another institution, so the state had agreed to run that concurrent. We're just trying to figure out the credit time served. So Mr. Middleton is the attorney. He continued the case, I guess. He filed a motion to continue this morning.
Well, I'm showing that there's no attorney on this case, according to the docket.
Madam Clerk, do you have Mr. Wellington being represented by Mr. Middleton? Yes.
Okay, you're David Wellington?
That's correct, Your Honor.
All right, are you represented by Mr. Middleton? Is he representing you?
That's correct, Your Honor.
Okay, well, he's not here today. What'd you say, that you wanted more time to?
The defense attorney, Mr. Middleton, just requested to continue it so we can work on getting your credit stipulated and all your credit time served figured out. And Mr. Middleton indicated in the email this morning that he would get with the clerk and the JA to schedule this case on the next miscellaneous docket. Okay, perfect.
Okay, well, that was the date I was going to give you. Let's set it, so we're going to reschedule your case for March 30th, and maybe you can get it resolved on that date. But we'll set it for March 30th at 9 a.m.
Okay, great.
Okay?
Thank you.
All right, good luck to you, sir.
Thank you.
What about, on your order, who do you have back? Do you have Reagan Phillips back there, perchance? Yeah. They're bringing him up? Okay. Oh, he's right there, okay. I've got him as number 6 on the docket. Oh, he's not. Okay, is Reagan Phillips here? Reagan Phillips. Okay, I've got him on the docket for 2021-1576 and 369. Shows that he's he's representing himself, is that right? What was it here for today?
Your Honor, this was a VOP arraignment. The last time we were here on February 28th, he failed to appear, but we discovered that the notice to appear by probation was sent to him and indicated Fort Walton Beach Courthouse. So then we reset it to have him set for today on 3/9. He's not here.
So the question is whether or not he was notified to be here today.
Well, we did, I believe that was the whole purpose of resetting it, so we could send him notice to be here. If we could get confirmation that he was noticed or sent notice with no return mail. And I received no indication from the South End Courthouse that he had appeared. Sometimes when defendants appear down there by mistake, we do get communication that we have a defendant that appeared down there. I've not received any type of communication indicating that he did appear down in February.
The last thing I show is on February 28th. Just as you said, he didn't appear in court here. I don't see that another notice was sent out. Well, it says notice created and e-served to Ms. Leah. I don't know whether he got notice for today or not, to be honest with you. Does the clerk see anything that indicates he was noticed to be here?
I don't.
All right. But you say you didn't get word that he appeared in the South End when he
Your
was
Honor.
noticed to be there.
I didn't get word from the defendant or any deputies or any courthouse staff in the South End that he had appeared down there by mistake.
Okay, let's do this. Let's issue a criminal summons for him, and let's make it returnable. Today's the 9th. Issue a criminal summons returnable for March 30th at 9 a.m. If he doesn't appear then I think it'd be appropriate to issue a capias.
Okay, thank you.
All right, Mr. Gibbs. Okay.
Judge, I can call some cases.
You want to call yours, Mr. Williams?
Robert Ham, would it work better for you guys if I called folks not in lockup? I can be flexible about this. Okay. Does it make a difference to you guys if I call folks in? Okay. Then Robert Ham, and I'll just go in alphabetical order, Judge.
Who's the first one you're calling, Robert Hamm?
Yes, sir.
Okay.
Hamm.
I have it.
This file's somewhat voluminous, so I'm just bringing a working file for my purposes today. Yeah, just follow their direction. All righty. Hey, Mr. Hamm, come stand over here next to me. Judge, Mr. Hamm's here on BOP arraignment. After speaking with him last night, I think he's got potential defense here. I'm going to want to talk to the people who are monitoring him. So he's not prepared to resolve it today. We need to pass him out to a later date.
Okay.
No, not yet. No.
What about March 30th?
Judge, I can certainly try to get it
Pardon
by
me?
that date. Hopefully they'll cooperate with me and I won't need to take depots. If so, I'll let the court know and we'll pass it again.
All right, let's put it on for March 30th at 9 a.m.
Thank you, Judge. And that can be without subpoenas.
Write that down for me.
I don't know if they're going to give you a court minute or not. Where am I?
All right, thank you very much.
There you go.
Thank you.
All right, sir.
I'm done?
Yes, sir.
Thank you.
Yes, sir. Who is this?
Harvey, Howard, Langley.
Howell.
Judge, this is Mr. Langley. We have a negotiated plea in this case. I did go over it with him, but there's no pass-through, so he was not able to sign it this morning.
Okay.
If this is what you want to do, I need to get your signature right here.
Right now?
Yes, sir, right now, if this is what you want to do today. If you don't want to do this today, you don't have to. You don't have to do this at all. Judge, since he seems to be hesitant, let me just go ahead and pass him until the 24th.
All right.
If we get something, we'll bring him in on another miscellaneous day. This was one that was passed for today because of issues with him being on lockdown week before last and me trying to see him.
I will pass it for April 24th at 9 o'clock.
Thank you, Judge. Yeah, you sure can.
Are you Misty Leon?
Yes, sir.
All right, good morning.
Judge, this is going to be a plea. We have a written executed plea agreement and a copy of the score sheet if I can approach.
Yes, sir. Ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you're Misty Leon, is that
Yes,
right?
sir.
Ms. Leon, your attorney's handed me a written plea agreement. It's dated yesterday. Has what appears to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did he satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case and any theories of defense of the charge with your attorney?
Yes, sir.
And are you satisfied with the services of Mr. Williams, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written
No,
plea?
sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is rendering this plea freely and voluntarily of your own will, is that right?
Yes, sir.
All right, the court's going to find then that has she pleaded nolo contendere?
Nolo contendere, Judge.
All right, I'm going to indicate that on here and I'll initial it. The plea of nolo contendere, case number 22 CF 3138, charging one count of possession of ammunition by a convicted felon, and count two charging giving false name to a law enforcement officer, is freely, voluntarily, intelligibly entered after defendants had the benefit of advice of counsel. The court will accept the plea, shall be adjudicated guilty on both counts, and she'll be sentenced to 10 months in the county jail. She'll get credit for all time served. She'll be required to pay court cost, $100 cost of prosecution, $50 public defender application fee, and a $100 public defender fee. And the financials will be reduced to a judgment lien. Ma'am, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. And this is a downward departure based upon a legitimate, uncoerced plea agreement. You will need to be fingerprinted.
Thank you, Judge. Judge, you want me to just call these in order?
I think that's easier for the jail because they bring them up.
That's fine, Judge. We can go ahead and do the jails first, and then I'll call the, that's fine. Is there anyone else here on the Daria Lewis case? Judge, we've been passing this case trying to get her a place to stay. From Probation told me a couple of days ago they sent somebody out and to the location, the address that we'd most recently given, and they said they didn't know Daria. I talked with Daria about it last night and was advised that they simply saw somebody show up with a badge asking questions, and they freaked out and said, I don't know who you're talking about. I was hoping that they would be here today for me to find out more and perhaps get some testimony from them under oath, but apparently she was either not able to get a hold of them or they elected not to show up. If I can have 1 second, Judge.
Your Honor, if I may, she has to abide by sex offender conditions, so she gave us an address. It was in Walton County. An officer with the probation officers went out to the residence that she gave to see if it fits the criteria of where she can live, and talked to the person at the house, asked them were there any kids there, was she able to comply within a bus stop rule or any kind of rule that deals with sex offenders. The person answered the questions perfectly, and then they said, well, who are you here to talk about? When we told her Daria Lewis, they had no idea who we were talking about.
And it may have been a roommate situation or something like that, and the roommate did not disclose to them what was going on, which certainly should have happened. At this point, where we are, though, Judge, is that the case has been passed probably longer. The ultimate goal here is to get her with her father in Tennessee, but they can't start the transfer paperwork with the case in this status, and we didn't want to leave her in jail pending the transfer of the paperwork. And the actual plea agreement provides for her to be able to withdraw her plea if for some reason the transfer doesn't go through. And then the prosecutor and I had agreed we'd go back, Ms. Bosage and I had agreed that we'd kind of go back to the drawing board and figure something else out. At this point, though, I think she's been in jail now longer than she would have been had I just pled her and it been an agreement that she stayed in jail until we got an answer on the transfer. Because my understanding is that you guys can do the transfer even if she's in jail. Is that correct? Or do the paperwork. Obviously, you can't guarantee she's accepted.
The interstate compact system. There is no skirting the interstate compact system anymore. You have to go strictly by what they say. Once she pleads, we can initiate a transfer. But she's going to have to stay in Florida. She's going to have to comply with the sex offender requirements while in Florida, and then it's up to Tennessee to take them. Tennessee has no obligation whatsoever to take them. Right. And I'll tell you, they frown very much on sex offenders, and if you have on GPS or anything like that, in good faith, I could probably tell you they're going to shoot it down.
Judge, first of all, we're not trying to skirt it. We're trying to work within it, which was why we were trying to find her a local address to stay until the paperwork could be processed. If we were trying to skirt it, and we were thinking somehow Tennessee wouldn't be able to shoot it down, we wouldn't have put in the provision that she'd be able to withdraw her plea if that didn't go through. So, frankly, I'm offended at the insinuation. We're trying to work within the system, and what I'm asking now is simply, if we'd done it the way you suggested before, and we had her waiting in jail for you to do this, would you still be able to make the application even though she's in jail and not at liberty out on the street? Assuming she's entered her plea.
Only after the court only after she's sentenced to supervision. We can't do anything until she is sentenced to some form of supervision. Not in our system.
Do we have a miscellaneous day that we can get her in when Ms. Bosal can be present?
March 30th is the closest date.
March 30th is the closest date. See, there again, I'm setting her off almost. I tell you what, Judge, if we can, let's let her have a seat back in back again. I saw her last night. I'll go around and see her again when Timothy's calling his cases.
I mean, there's a miscellaneous date tomorrow, but I don't know that you're going to get it resolved by tomorrow.
I'm assuming she's still going to be in trial. She's in a trial week, and that's the problem with her being here today. And I don't want to do anything that she hasn't agreed to.
Right. And the next date I'm showing is March 30th.
If we can put her back, I'll talk with her while I'm seeing Tim's cases. Or while Tim's seeing his cases. Judge, we'd made a counteroffer in this case. It was rejected. At this point, I'm going to ask the court to set it on for the April 24th docket, and I'll take depositions.
All right, we'll set it April 24th, pretrial May 1st docket day, May 8th jury selection.
Thank you, Judge.
Yes, sir.
Okay, Mr. Martinez. Judge, this is Jesse Nixon. Sorry, Judge. We have a negotiated plea in this case.
Never said anything about credit for time served on there.
It doesn't have to. By law, they have to give you credit for time served. It's in the statute. So the only time I ever put it in a plea agreement is if there's something weird about it, like they're getting credit for time served on something that they otherwise wouldn't be entitled to, or if the guy just refuses to listen to me when I tell him it's automatic. This is what you want to do. I need to get your signature here. Judge, I've gone over this with him. I've been out to the jail to see him several times. Yes, sir. Today's date is the 9th. Okay. There's just no pass-through, so.
All right, sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Sure.
Thank you, sir. All right, you're Jesse M. Nixon, Jr., is that right?
Sure.
Mr. Nixon, your attorney has just handed me a written plea agreement. It's dated today, purports to have your signature on it. And I'll ask you, is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it? Did you go over it with your attorney? Did he satisfactorily explain the terms and conditions of the written plea to you? Do you have any questions concerning it this morning? Are you satisfied you've had sufficient time to discuss the case and any theories of defense to the charge with your attorney? And are you satisfied with the services of Mr. Williams, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
So what you tell me is you're entering this plea freely and voluntarily of your own will, is that right? All right, the court's going to find that the written plea of nolo contendere, case number 22 CF 2380, charging in count 1, fleeing and attempting to elude a law enforcement officer at high speed. Count 2, leaving the scene of an accident with property damage. Count 3, driving while license suspended. And in case number 21 CF 2964, fleeing or attempting to elude a law enforcement officer at high speed. Count 2, attaching an improper tag. Count 3, driving license suspended. Count 4, leaving the scene of an accident with property damage, is freely, voluntarily, intelligibly entered after defendants had benefit advice of counsel. The court will accept the plea. And on all felony counts, that would be counts 1 on each of the 2 cases. He'll be sentenced to 30 months Department of Corrections to run concurrent, one with the other. He'll get credit for all time served. The court's going to impose court costs amount of $448 on each case, $100 cost of prosecution each case, $50 public defender application fee on each case, and $100 public defender fee on each case. His driver's license will be suspended or for a period of 5 years. And on case number 21 CF 2964, he'll be required to make restitution in the amount of $5,671 to Florida Light and Power Company and $148 to the United Methodist Church. In case number 22 CF 2380, he'll be required to make restitution to the Florida Department of Transportation. The court will reserve jurisdiction for a period of 90 days to determine the amount, manner, method of payment of that on those in that case. On the misdemeanor charges, that's counts 2 and 3 in 22 2380 and counts 2, 3, and 4. I presume, I don't see it on here, but I presume he's going to be sentenced to time served. Is that right?
That's correct, Judge.
He'll be sentenced to time served, no additional fines and cost. So you have a right to appeal the legality of the sentence of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days to file your notice of appeal. You will need to be fingerprinted on these charges. And the DOC case, on both cases, the 30 months will run concurrent one with the other, and he'll get credit for time served.
That's it. I've got some civilians to call.
Okay.
Let's see. Misty Johnson. Judge, this case was passed last time so that she could retain private counsel. Ma'am, have you done that? Yes. Okay.
I was supposed to meet with him Tuesday.
Madam Clerk, do you have a notice of appearance filed by anyone else? Misty Johnson is going to be 18 CF 2208.
Who did you hire, ma'am?
Filed until Mr. Charles Reed, but it won't be until Tuesday. I have to take him the payment Tuesday. Oh. I have an appointment to meet him.
Judge, let's pass it out one more time. Let her do that.
All right. We'll pass it out to, let's, since we got the issue of whether or not she's going to retain, let's do it to March 30th as opposed to April 24th.
That's fine, Judge.
And, ma'am, you need to be back in court on March 30th at 9 o'clock with your attorney.
Yes,
or
sir.
he needs to file the paperwork, and he'll know what to file.
Yes, sir.
Otherwise,
Thank
you need to be back in court March 30th.
Yes, sir.
Thank you, Judge. Jacqueline Lige. Your Honor, Ms. Lige doesn't answer the call of the court, and I don't see her in the gallery.
Is this the one that you were going to try to get in touch with and bring her in today?
Yes, Judge. I've called twice, including trying to call her daughter, was not able to reach anybody. My secretary's tried calling, has not been able to reach anybody. I don't have any answers for the court.
So it would ask for a capias with no bond.
All right. She's on a signature bond. So let's, well, it's a signature bond. So issue a capias for her arrest, failure to appear, no bond pending first appearance.
Thank you, Judge. Judge Holly Nielsen. Judge, we've been passing this case to get Ms. Nielsen finishing up some of the terms that have gotten her violated. Ms. Nielsen, did you bring any of the paperwork?
Bridgeway said it takes 5 to 7 days to get that.
Okay.
5 to 7 days to get it.
All right, Judge, let me elicit some testimony from my client.
What's it here for? The VO?
Well, we've been trying to, one of the reasons why she was violated, in fact, I think the primary reason was that she was supposed to go to Bridgeway and begin the evaluation treatment process. She advises me, and what I want to elicit under oath is that, because we've been back maybe 2 or 3 times now.
A lot of times.
That she has been to Bridgeway, she's completed the evaluation, has already begun counseling. I asked her to get paperwork and bring it in to court for today to show that she had done so. She does inform me that Bridgeway tells her that it's going to take 5 to 7 days to get that. My first set of experiences with Bridgeway was when I was the domestic violence prosecutor in Santa Rosa, and frankly, we had issues using them for batterers intervention program, DVIP, mental health evals, all that stuff, because they just wouldn't send us reports. So it kind of has the ring of truth about it to me. But I wanted to go ahead and get her under oath and elicit this under oath because I think what I'm inclined to do is ask to pass it until the 30th. Maybe she'll have completed the program by then, and we can simply put her on a regular termination date.
All right. Ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Would you please state your name for the record?
My name is Holly Nielsen.
Ms. Nielsen, are you the Holly Nielsen listed in these cases, 21 CF 1726 and 21 CF 386?
Yes, sir.
All right, tell the court what the situation is right now on your attendance at Bridgeway.
Okay, I did the substance abuse evaluation, and they recommended that I take 12 weeks of drug classes, starting this coming up Tuesday from 12 to 1 every Tuesday. And he had asked me to get my paperwork to bring to the court, and whenever I called him and asked them, they said that it would take 5 to 7 days for them to get that paperwork together for me to be able to bring it up here.
Any cross? You have anything else?
No, Judge.
Any cross?
And Bridgeway told you about the 5 to 7 days that they needed, you said on Tuesday?
I can't answer, just answer to the best of your recollection.
That was, I think it was Monday.
She seems unsure, but it was recently.
So you were asked to do this February 28th of 2023, right? That's when we were here last?
I talked to my lawyer on Monday. He asked me to bring the paperwork then, and I called him and asked him, and they said take 5 to 7 days to get the paperwork together. That was this Monday.
And how many classes have you taken or Bridgeway so far since you? I'm sorry.
1. Mm-hmm.
And can you not take any other classes until further ordered by the court?
No, that's every Tuesday from 12 to 1 for 12 weeks.
So you've only taken 1 class so far?
Mm-hmm.
I don't have any other questions.
All right, ma'am, I know you're a little bit unsure of the day, but were you at Bridgeway this week?
Yes, sir. I started my class this past Tuesday.
Okay, now you know you were there Tuesday.
Mm-hmm.
And what did they tell you on Tuesday? Did they schedule another class for you? When is that?
Next Tuesday. Every
Okay.
Tuesday.
All right, and they told you, as I understand your sworn testimony, they told you that they could have paperwork for you within 5 to 7 days.
Sir.
So that would be by Tuesday of next week.
Yes, sir.
Is that right?
Yes, sir.
All right. And you understand that you're under oath, and if you're not telling us the truth today, you can be prosecuted for perjury. Do you understand that?
And Your Honor, probation has indicated he would do us a favor and reach out to Bridgeway and see how that process is coming along. He can.
Within the next, just pass her for a second. I can contact our officer and see if she's began.
All right, we can do that, or what I was going to do was put it on, she's obviously got more classes to do.
Yes.
So I'm going to put it on the docket also for March 30th. That would give her more than enough to get the proof that she was there.
We'll
And,
make sure we have that information to the defense attorney and the prosecutor.
okay. Let's put it on for March 30th for review to make sure that she's been going to Bridgeway as she's testified to.
So has she been accepted into Bridgeway, or is that what we're waiting on?
No, my understanding is that she has the evaluation. That was done, I guess, a week ago. And then they referred her to classes, said her testimony was that she needed 12 classes, and she began the first of those 12 classes on Tuesday.
She needs 12 classes.
She's not inpatient, she's outpatient, she's going to the drug classes.
So she's been accepted.
Well, yes, ma'am.
Okay, so we can resolve this case then and include Bridgeway as a condition, so I'll get with you on that, okay? If she's been accepted, I thought she was waiting for acceptance.
No, she's actually already been started classes.
Okay. Well, then-
Do you want to just go ahead? Complete Bridgeway? Okay, we can do that.
Okay, let's pass it then.
I presume she's already entered a plea, is that right?
Well, she entered a plea to the underlying case. She's
Right.
here on a violation of probation because she hadn't gone to Bridgeway. And so I am doing what I normally do on a VOP is, hey, go ahead and get everything you're supposed to get done, and, then you're in a much better position.
All right, I see what you're saying. So so she hadn't admitted or denied the violation at this point?
No.
Right, it's been pending. I mean, she was served with this VOP warrant back in August. So if she is doing Bridgeway as a condition, we need to get her to admit the probation, let's reinstate her, and add in the condition of Bridgeway.
We can go ahead and do that today, Judge. She's been standing here, and I turned to her a minute ago and asked her if she wanted to do that, and she indicated that she does. Am I right? Is that what you
Yes,
want to
sir.
do? With that, Judge, we'll go ahead and enter an admission.
All right. Based on that, I'll go ahead and find she has in fact violated her probation. She'll be adjudicated guilty of the violation. I'll restore her to the probation that she was previously sentenced with the additional condition that she attend and successfully complete the evaluation and follow-up treatments at Bridgeway Center. And that's for I presume, drug rehabilitation.
Yes, sir.
All right, ma'am, you have a right to appeal, 30 days to appeal. If you can't afford an attorney, one will be appointed for you.
Thank you, Judge.
May I approach with a score sheet, Your Honor?
No, you won't have to come back March 30th. You will be back on probation. I don't have any objection. Yeah, you need to go sit over there.
All right, that's all your cases, Mr. Williams, except for Ms. Lewis. Is that right?
That's correct, Judge. I've got some for arraignment this afternoon, but I'll duck out and speak to Ms. Lewis now.
All right, let's take a short recess. Let's take about a 15-minute recess. We'll be in recess until 10.
Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Judge, this is Daria Lewis approaching 21 CF 1685 and 21 CF 1697. I've spoken with Ms. Lewis. We passed her a few minutes ago. What we're going to wind up doing ultimately on this, and when I say ultimately, I mean tomorrow, is entering a plea to the same agreement that we already had, which was a suspended DOC sentence and restored to supervision, but with a provision of 60 days county jail to be suspended upon acceptance by Tennessee. And that will give some time and make it possible for probation to go ahead and start doing the transfer paperwork. It's already part of the plea agreement that she's allowed to withdraw her, or that it will come back into court for a modification or withdrawal of the plea if Tennessee won't accept her. Both Ms. Bosile and I are pretty firmly committed to trying to get her up to where she's living with her dad and she has better supervision. I do want, though, to email Ms. Bosile about it so that she doesn't feel like I'm doing anything behind her back. We have good working relationship, and I don't want to do anything to harm that. So I've already spoken with Ms. Leone, who's here on her behalf. I'm going to send that email out, CC Ms. Leone, and if we can have Ms. Lewis come back for tomorrow, it looks like we'll be entering admission to the VOP tomorrow.
All right, so you just want to put her on the docket for tomorrow right now?
Yes, sir.
All right, 9 o'clock tomorrow.
Thank you, Judge.
Yes, sir.
All right, I'll see you tomorrow, okay?
All right, that looks like that takes care of your cases for this morning.
Yes, sir. I've got some this afternoon, but if I can be excused,
Yes, sir.
I'd appreciate it. Thank you.
All right, we'll see you this afternoon. Mr. Gibbs, you're
Yes,
up.
Your Honor, thank you.
Your Honor, if I may, before we start, I don't know if the JA communicated with you that at this hearing, we need the Zoom technology on because the victim's family, they have a right to participate. They're out of state and they requested to participate via Zoom.
For what, this hearing here?
Yes, Your Honor, for this hearing.
No one indicated that to me.
I have emails. 1 second, Your Honor.
Did you file a motion for that, Ms. Leone?
No, I did not.
Okay.
Who are there are some people in the waiting room.
One is Miss Cosgrove, the victim's sister.
I don't see, well, it could be under a phone number. There's just a phone number. There's a Rihanna Treadwell. Is she involved in this case?
Not that I know of, Your Honor. I'm trying to access the email correspondence that I had, I think, between my assistant and the court.
Do you know how to get Zoom up, or? I have an Amanda Wybring in the waiting room and a Rihanna Treadwell and then a phone number.
Judge, it looks like your video is off as well as you are also.
Well, I know it is. I'm trying to figure out who's here for this hearing.
I don't know who any of those are.
It was only gonna be Miss Cosgrove. I don't recognize those names.
Well, let's see what they're here for. right, good morning. I have a Miss Treadwell. Are you there, ma'am?
My name's Cosgrove.
Okay, all right. And there's also an Amanda Wybring.
And that's the other sister, Your Honor. No, I didn't recognize the last names because I thought it was Cosgrove, but I do know Amanda and the other Miss Cosgrove.
All right, well, that's everybody then, is that right?
Yes, Your Honor.
All right, there's somebody on by phone which is not identified. Is there anyone else online other than Miss Cosgrove and Miss Wybring?
That was me, just in case it didn't go through on here.
Okay, all right. So we've got everybody we need. Is that right?
Yes, Your Honor.
Yep.
Okay. All right, what's the situation then?
Your Honor, Tim Gibbs for Ms. Ainsworth, 23 CF 178. Judge, we're here for a motion to reduce or modify bond. Judge, she is currently charged with DUI, manslaughter, as well as vehicular manslaughter in this case. This incident occurred June 17th, 2022. She currently has a $200,000 cash professional bond total. She is unable to make that bond. She is requesting a reasonable bond that she can make. She believes that she can make a $2,000 cash professional bond on each count for a total of $4,000 cash or professional. She is, of course, amenable to pretrial supervision to include GPS monitoring due to the nature of the charges. Judge, she's lived in the area for 15 years. She would reside here in Crestview. She is employed locally with condo cleaning, has her GED. I don't believe she's ever failed to appear in court. This incident in question, Judge, was over 6 months ago. She was actually at the scene. She did not leave the scene, according to the arrest reports. She was taken to the hospital for an evaluation. The officer at the scene believed that she may have been under the influence of substances because she was acting very nervous. She was acting very anxious, very jittery. She is a very anxious person. The court might be able to see that she's composing herself quite well this morning, but she's otherwise very nervous. She did also turn herself in, Judge, immediately after learning about the warrant. The warrant came out a few months later after a blood draw was done at the hospital for a search warrant. She's on Medicaid, Medicare, and disability, Judge. She currently requires treatment for congestive heart failure that she has appointments for, and I'd like to elicit some testimony from her regarding that as well, if I may.
All right, ma'am, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you tell the court about your medical condition?
Yes, sir. It's been declining. I'm I have congested heart failure along with borderline diabetic. My heart is like only working so much percentage, and I really need to get back on my medication due to the heart like failing. And the last time they gave me the stress test, my heart was only producing like 42% of the I don't know how you want to say it, the beat of the heart. In other words, it's only beating 42% instead of at the 100% mark. Not including that, but they found a spot of they said they do believe it might be cancer on the spot on the left lung. I fought breast cancer for 4 years, got in remission, and then now there's a spot on the left lung, which I haven't been back to the doctor to get that confirmed to see if it is cancer or not. I got to go to Pensacola for that.
And so, Ms. Ainsworth, before you were arrested, were you seeing medical professionals for those issues?
Yes, sir, I was.
How often would you see them?
Well, during the COVID, there was like a time period there I wouldn't even go to a doctor, because I was too scared to go, and, stuff like that. But the last time I went to the heart doctor was probably about 1.5 years ago, and they told me I really need to be back on my medication, and I just threw myself into my work and stuff like that because I was going through a hard time of losing everything I had.
When did you find out about the warrant in this case?
January the 15th, I think it was, or 16th, and I turned myself in immediately when I called the Crestview Police Department, and they told me, and I told them I was at work, and if they give me a couple hours, I'd turn myself in, and I did so the same night, as I told them I would, and I met them at the Crestview Police Department, to Officer Tingle and the officer, I can't pronounce his name, but he was the commander of the lieutenant of the Crestview Police Department. I turned myself into them at 9 o'clock that night, like I told them I would be, and I did, and I'm here. now.
Thank you, Ms. Ainsworth.
Sure.
Those are my questions, Judge.
Ross?
I have a few questions. Miss Ainsworth, have you ever lived in Alabama?
Yes, ma'am.
When did you live there?
Oh, all my life until about 15 years ago.
While you were were you in Alabama on February 6, 2008?
February 6, 2000, ma'am, I don't know. I have no idea. I could have been, I don't know.
How about in 2004, September 2004?
I could have been.
Were you ever arrested around those periods of times in Alabama?
I have no idea, ma'am. I have no clue of the dates or anything like that.
But were you arrested while you were residing in Alabama?
I have been arrested while I was in Alabama, yes, ma'am.
What were you arrested for?
I got arrested for domestic violence on several charges, and I had a DUI in Alabama.
How many DUIs did you have in Alabama?
I think I had 3.
Here may I approach defense. I'm showing defense. I haven't pre-marked it, but it would be State Exhibit 1, 2, and 3. Could you ask your client if she recognizes those?
Do you recognize any of these tickets, any of those dates?
Not right off, I don't remember the dates. You know, I do not remember that at all,
But
you know,
is
the
it true on those
dates.
convictions, Ms. Ainsworth?
Did you have any prior convictions?
I could have. Like I said, I ain't gonna lie, I'm not gonna perjure myself underneath the oath. I have got a DUI in Alabama. I sure have.
Your Honor, this time the state moves State Exhibit 1 into evidence.
I would object, Judge. It appears that it's impeachment evidence. Ms. Ainsworth is not denying that she's had a prior DUI. She's not denying that she was convicted. She simply is saying that she doesn't remember. As far as impeachment evidence, that I would object to that purpose.
How many is she saying she's had in Alabama? I thought I heard her say 3.
That was what I heard as well, Judge, and I see 3 separate citations for DUI.
Are there any more than 3?
No, there are 3, and there is a reason. This is not for impeachment, Your Honor, that I'm offering it. I'm offering because for the purposes of the bond motion, I'm trying to show that, first of all, the present incident would be the 4th DUI. That's an additional felony that the state is going to be filing charges on. So again, I'm going to renew my motion to move into evidence, State Exhibit 1, 2, and 3.
I'm going to sustain the objection. You asked her how many DUIs she had. She said 3, and apparently that's how many she's had. That's what your evidence shows.
Yes, Your Honor, so I cannot introduce it?
I'm
Move it.
sustaining the objection.
Thank you. Ms. Ainsworth, did you ever post any message on social media regarding this incident?
Yes. I sat there and somebody said something about me and I responded back, yes, ma'am, I have.
Now, you said that you turned yourself in with Crestview Police Department as soon as you found out that there was a warrant for your arrest.
Yes, ma'am, I did.
No further questions, Your Honor.
Anything else?
I don't have any follow-up on that, Judge.
Anything else, counsel?
If I may ask, Your Honor, Ms. Cosgrove submitted some photos of the incident to us, of the motorcycle that Mr. William Cosgrove was riding at the time that he was hit by the defendant.
She's charged with 2 counts of vehicular homicide or DUI manslaughter, is that right?
That is correct, Your Honor. Count 1, DUI manslaughter, count 2, vehicular homicide.
Okay.
Any objection to this photo?
I'm going to lay the foundation for it, sir.
I'm not sure Ms. Cosgrove can see this photo for me to authenticate it through her.
I think you'll have to bring it up here unless you have a
May I?
camera on your.
I don't have a camera on this, but may I approach?
Yes, ma'am.
Ms. Cosgrove, can you hear me? Well,
Yes.
Would she need to be placed on the oath, Your Honor?
Yeah. Ma'am, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Can you see this photo, ma'am?
Yes, I can.
Can you tell the court what it is?
That is a picture of my brother's motorcycle that was taken in the tow yard within a week of the accident.
Do you know who took this photo?
I did.
Is it a fair and accurate representation of the motorcycle your brother was driving at the time of the incident?
Excuse me?
I'm sorry, is that a fair and accurate representation of the motorcycle that your brother was driving at the time of the incident and that was in the impound lot that you took photos of?
Yes.
Your Honor, the state moves State Exhibit 4 into evidence.
Any objections?
I don't think I have an objection, Judge.
All right,
I think
I'll
she
admit
laid
it.
the foundation.
State's Exhibit 4, you said?
Yes, Your Honor, if I may approach. Ms. Cosgrove, before I start either arguing or questioning you, do you have any statement that you would like this court to know that it relates to the bond reduction that Ms. Ainsworth is seeking today?
Yes. My family is very concerned about the well-being of the community that she surrounds because as many of you guys that have familiarized with it yourself with this case have realized that it's been 7 months since this has happened and she is now just being charged with it. So this not being her first OUI and this being actually her fourth, because the toxicology reports have stated that she was intoxicated, that she will again take the chance on injuring the lives of the people that she surrounds, not only in the community, but people that she's around in general, that I feel she could receive adequate medical care in jail. I don't believe that the state of Florida is going to deny her medical care. So I don't feel like she should be released just because she wants to receive medical care, because by law, correct me if I'm wrong, she has to be given medical care. So that's not a good defense to put the community in danger again for what would be the fourth time or the fifth time, because this is the fourth time now. And she continues to do it. So who's to say she's not going to turn around and do it again and hurt somebody else?
So, Ms. Cosgrove, do you believe that the amount of the bond as it is set right now of $200,000 total, is it appropriate?
Yes.
Thank you. I don't have any questions for Ms. Cosgrove.
Any cross, Mr. Gibbs?
No cross, Your Honor.
All right. Anything else?
I don't have any other witness, Your Honor.
Anything else, Mr. Gibbs?
Judge, again, the primary purpose of a bond is to ensure court appearance. As Ms. Ainsworth testified, she did turn herself in as soon as she understood the warrant, or as soon as she understood the warrant was active and that law enforcement would be searching for her. She is wanting to resolve this as quickly as possible. She's wanting to be very active and involved in her case and seeing this case through. I would imagine that her license was suspended as a result of this by the Department of Highway Safety and Motor Vehicles. So I would imagine she has no intention of driving in the future. And thus, since she cannot afford a $200,000 cash or professional bond, we request a total of $4,000 with GPS monitoring if necessary, is certainly on pretrial supervision, and any recommendations for substance abuse counseling while she's on pretrial.
All right. 3 prior DUIs, no, I'm not going to reduce it. Motion for bond reduction is going to be denied.
Understood, Judge. I believe she's already set for the pretrial on the 24th, if we could leave her set that day.
We'll leave it set that day.
Okay, that's it.
Thank you, folks.
Thank you.
Thank you.
Your Honor, Tim Gibbs for Wendy Boardman, 22 CF 1407. Judge, we're asking to put Ms. Boardman for the 30th. We've been in contact with a few different places regarding treatment options for her and looking into those, so we'd like to set her for that date to get those finalized.
Objection.
All right, we'll set it for March 30th at 9 a.m.
Thank you, Judge.
Thank you.
Your Honor, Tim Gibbs for Gladys Chancey, 16 CF 1505. Your Honor, the court previously found Ms. Chancey not restorable after she had been found incompetent to proceed. Judge, I believe ultimately at this time the only option is that the court or the state can either Baker Act her through essentially institute civil commitment proceedings under the Baker Act or release her. That's based, Judge, on Mosher v. State, 876 Southern 2nd 1230. Which also cites Jackson v. Indiana, 406 U.S. At 738. Essentially, Judge, since she's been found non-restorable, she needs to be released. I've spoken with the state on potentially putting her on mental health pretrial supervision with a GPS monitor, having no contact with the alleged victim in this case. I believe she is intending to seek a divorce. I also know that the alleged victim has now filed a petition for an injunction for protection against domestic violence, and a temporary injunction has been put in place. She does have a hearing on Tuesday. I am not sure if she will be transported to that hearing, and I can't answer as to what options she would have considering the finding of incompetency regarding how she would go about defending herself in that matter. But ultimately, Judge, we're at a situation where the law states that she is to be released.
She's been in that status for more than 5 years? Is it?
She has not been found incompetent for more than 5 continuous years, Judge. The last time the last time she was found competent by this court was in January or March of 2020. There was a break from October of 2019 until January or March of 2020 where the court did find her competent, so it has not been 5 continuous years. However, the first time she was found not competent to proceed would have been March of 2017.
Your Honor, I cannot object in good faith to the statement of the law as the defense counsel has announced. However, I need to place on the record that the state's main goal is to protect the victim and the community. To that end, I know Mr. Chancey is present here in court today, and I would want to inquire, if the court allows me, whether or not Mr. Chancey has a statement that he would like to make to the court. Mr. Chancey, would you like to address the court?
Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? Yes, sir. Have a seat, please.
Mr. Chancey, please state your name for the record.
Name is Mark Chancey.
Do you know the defendant, Ms. Chancey?
Yes, ma'am.
How do you know her?
She is my wife.
Now, we know that you were involved in an incident with your wife back on June 24, 2016. Since then, your wife has been incarcerated and sent to Florida State Hospital several times. How did you, as far as safety is concerned, how have you been feeling all those years?
Scared to death, to be honest with you. It's kind of difficult to put into words, but I'm not scared of many things in my life. But my complete trust was in her. And I trusted her so much on that day, it nearly cost me my life. And I am deathly afraid, to be honest with you. I don't know how else to put it. Protection, I mean, I've purchased security systems, I've changed all the locks on the doors, but I still don't feel safe.
Have you tried to seek some sort of protection legally?
Well, on Monday, I did file an injunction because I thought in 2016, being a victim of domestic violence, that was something that was automatically done. And obviously it was not. Now, I had the comfort knowing that she was incarcerated and could not get to me, but that still doesn't take that fear away.
Now, as we previously discussed, we have information that Ms. Chancey will live in Walton County. Would that help with your concerns for your safety?
Walton County is fine. It doesn't matter to me as long as I'm protected, as much as I can possibly be protected. She can live with her family. I don't care. I just don't want to see her or have contact with her or her to have access to my family, my friends, my residents. That is the main, I apologize. That's my main concern is I want to be safe. I want this to be over with. It's over 6.5 years old. And I honestly want it to be over with, but I don't believe a piece of paper is going to keep me safe.
Now,
So
Mr. Chancey, if I may ask, are you still married to Ms. Chancey?
Yes, ma'am, I am.
Have you initiated any divorce proceedings?
I have spoken with several attorneys, and speaking with those attorneys, the Florida divorce laws or Florida civil laws are not in my favor. I mean, we were bankrupt, the house in foreclosure in 2016. We've only lived in that house for 6 months prior to this incident happening, using my VA, my income to pay for everything. And since that time, I have paid off all of my bills, even paid her delinquent medical bills to keep the creditors off of me. Caught up on everything, done repairs, replacing air conditioning systems, the flooring, all appliances in the house, all on my own, with my own money. And I'm told by 4 different attorneys that none of that matters. She's still going to get half of everything.
Mr. Chancey, for the purpose of this hearing,
yes,
and your safety, would it be fine if there was a court order that prohibited her from coming close to you or your family, to be within 500 feet and contacting you? And if she were to reside in Walton County with her sister, as she's indicated through her attorney?
I am fine with the residing in Okaloosa or Walton County. I am not fine with the 500 feet. I feel that she should reside in Walton County and remain in Walton County unless she has a specific appointment in Okaloosa County or passing through Okaloosa County, because it's not just me that I'm concerned with the safety for. Ultimately, it is myself being the victim, but there have been letters sent to family members and other people that I know that they were threatening in some way or another, and I look out for their safety too. So it's not just my residence or my vehicle or whatever, it's my family members also. So I don't know that the 500 feet is far enough for me.
I understand, Mr.
So,
Anything else you want to say? I don't have any other questions, Your Honor.
Cross?
Yes, Your Honor, thank you. Kind of go that in reverse order, Judge. Mr. Chancey, you said that your wife has sent you threatening letters?
well, she hasn't sent me threatening letters. She's given them to family members, and I received one of those letters.
To your family members?
Well, our family member, my daughter, stepdaughter, she has been given letters, and I received one of those letters from her, and I have read it and immediately turned it over to the state attorney's office.
But she wasn't specifically threatening that she was going to try to hurt you or kill you in those letters, was she?
No, because she already did.
Do you know how far 500 feet is?
Yes, sir, I sure do.
You know it's a lot longer than a whole football field, right?
Actually, it's 5 football fields.
500 feet is
Well,
500
feet, yeah, is about a football field and a half, yes, sir.
That's a pretty long distance, isn't it?
Yes, sir, it is.
You also mentioned that you had filed an injunction, is that correct?
Yes, sir.
And you didn't do that until Monday?
Excuse me?
You didn't file that until Monday?
I did not do that until Monday. I did not know I had to.
And in that injunction, you're also hoping that she forfeit all of her marital assets?
Absolutely.
Okay. Because your words actually earlier were that Florida divorce laws are not in your favor?
Correct.
Not that they're fair, they're just not in your favor.
Well, I don't believe they're fair in this case, a domestic violence case.
How long have you been married?
Well, a little over 30 years.
How long were you married on June 24th, 2016?
29 years.
Now, you also talked about financial difficulties as well when this incident happened. Have you received financial assistance from anyone else since that?
I'm sorry?
Have you received financial assistance from anyone else since this incident occurred to
No,
help
I
you with
did
your
not
finances?
ask for any assistance.
I didn't ask you if you asked for any assistance. I asked, did you receive any assistance? Did anyone else pay your finances?
No. I did have a family member while I was recuperating pay a power bill, I believe a mortgage payment, and I, in turn, as I was recouping, when that was over, I paid all of that back to them.
So nobody else has helped you with your finances? Nobody's helped you get out of bankruptcy or get out of debt?
No, sir.
You also talked about, I think, security cameras earlier, is that correct?
Yes, sir.
Those were installed before June 24th, 2016,
No, they were
weren't
not.
They were not installed, they weren't
When
attached
we
to the house?
purchased the house, there was a security system in the house that did not work, and we never turned it on. Matter of fact, I I don't have that. The security system never worked in that house, and I installed one that had cameras.
Why did you not file for divorce way back in 2016 when this happened?
Because, again, looking for legal assistance, the divorce laws in the state of Florida, not being fair to a male victim of domestic violence, for one, and number two, I have spoken to a couple of attorneys and said, they asked me what is the penalty for her charges, and the attorney told me, well, then don't get a divorce. If she's going to be in prison for the rest of her life, then why bother getting a divorce?
So attorneys told you to not get a divorce?
Absolutely.
Because you wanted assets?
Excuse me?
Because you wanted assets?
No, because I worked hard for everything that I had, and this person tried to take everything from me, including my life. And why should they recoup or get anything when they tried to take everything from me?
Have you been filing her on your taxes every year?
Up until this past year, yes.
So since 2016, considering she's been incarcerated and making no income, you've been filing her on your taxes?
Yes, sir.
You get a refund?
With approval, yes, I did. With approval from family members.
From family members?
Her family members that had a, what's it called? A power of attorney, a financial power of attorney for her. And those income tax returns were all approved by them, and they received half of the proceeds along with any of the, what were they, the stimulus checks that was received during that period. They were also given that, her portion of that money also.
But you never actually got approval from Ms. Chancey directly that you could file her on the taxes?
I got approval from the daughter.
Do you know when the daughter got power of attorney over Ms. Chancey?
I have no idea.
Those are my questions, Judge.
This case sounds familiar. Was this before me last month?
Yes, Judge.
Yes, Your Honor.
See, what's been done since, has the state initiated civil proceedings?
No, we can't.
So, I mean, again, the state could ask for a Baker Act. That's certainly within the, confines of the law. I believe she was assessed actually on January 19th. She had an assessment in the jail by a jail psychiatrist as to whether or not she met criteria. She hasn't been removed from the jail since then, so I think it's safe to say that she does not meet Baker Act criteria.
And the last order that was entered was her competence is not restorable.
Correct.
To stand trial.
Correct.
And it's been over 5 years since she was arrested on this charge.
Yes, Judge, she has been in jail since.
I don't know what authority I have other than to dismiss the case. Is there any authority from the state that you could?
Well,
And-
what
and-
Mr. Gibbs stated, she hasn't been continuously incompetent for the 5 years required by statute, so we're short approximately 2 years.
So, again, Judge, there was a break. Originally, she was found incompetent to proceed in March of 2017. That persisted until October of 2019, when Judge Flowers found her competent to proceed. There was a report that indicated she was malingering, which Judge Flowers agreed with and found her to be competent. Then in January or March of 2020, she was found incompetent again by the court and sent back to the state hospital at that time, I believe, for the 4th or 5th time. So the continuous requirement of the statute indeed has not been met of the full 5 years. Otherwise, again, since she is not restorable, she either should be Baker Acted or released. And if the court did dismiss it, that, just to make the record clear, that would still be without prejudice. If she is found competent in the future, the state could bring charges notwithstanding statute of limitations.
Well, let me ask the state this. Does the state intend to go forward with this prosecution?
Well, it depends on the mental condition of the defendant, because right now she's incompetent. Additionally, about the Baker Act situation, we had a hearing where the expert testified that based on the testimony, I don't believe she would meet the criteria for Baker Act because she doesn't present a danger to herself, neither to the public. Those are the two main criteria, I guess, for Baker Act. It's obviously, Your Honor, a very egregious charge. Obviously, Mr. Chancey has indicated he's afraid. However, he is working on building safety around himself. I don't know legally what other recourse I have at this particular time.
What do you? All right, anything else, Mr. Gibbs?
No, Your Honor, I think that covers everything.
All right, anything else?
No, Your Honor.
All right, I'm going to order that she be released under pretrial services. She's not to come within 1,000 feet of the alleged victim. She's not to be in possession of or use any type of alcohol, illegal drugs, or controlled substances. She'll be on GPS monitoring, and she'll have to, and then the state's going to have to make a decision whether or not they're going to go forward on it or not. But it's my recollection that the state doctors found that she was not competent, or they found that she was. They send her up here, and as soon as she got up here, that she was found to be not competent, so they'd send her back to the state. And it was almost like a ping pong ball going back and forth. And in the interim, more than 5 years has passed. And I think the intent, or at least the spirit of the statute, is that she be released based upon her mental condition. But do you understand that, ma'am? You're not to be and you're not to contact him in any way whatsoever. She's not to be in possession of or use any type of weapons.
I have no desire to contact him, Your Honor.
All right. And then the state, you want to put this back on the docket?
Do we need to leave it for pretrial, or?
Yep.
And we'll
Are y'all going to have her examined again?
We may consider that, Your
In
Honor.
that case, let's put it back on April 24th for pretrial.
And hopefully by then, Your Honor, we may have a final decision for the whole case.
Okay.
And Judge, they do have an injunction hearing on Tuesday. I just kind of wanted to make the record clear that even though the court has now ordered that she be 1,000 feet away from Mr. Chancey, and indeed also that the temporary injunction says 500 feet, I just want to make it clear for her conscience that she is still able, of course, to attend that hearing since she is the respondent in that case.
Right.
So, yes.
But I want her to understand that if the injunction is issued, you're talking about DVI.
Correct.
If it's issued and it only says 500 feet, my order still says 1,000 feet regardless.
Understood. Thank you so much, Your Honor.
Thank you, Your Honor.
All right, Lynn Edward Banks.
I don't see any response, Your Honor.
All right, is he out on bond?
Your Honor, he was scheduled to be here on Monday. He was scheduled for the 6th after he was not here on the 27th. We had scheduled him for the 6th and asked him to be here. I believe we've made contact with him since, and again, I do not see that he's sounded the court. If we could just wait until the afternoon docket, perhaps he may show up then, and we can, he already has a capias.
We'll deal with it this afternoon if he shows up, but in the interim, I'm going to issue a capias for his failure to appear, no bond pending. Oh, it's already been
Yes,
issued.
Judge,
Okay.
that was issued on Monday by Your Honor.
Amber Coward.
Your Honor, Tim Gibbs for Amber Coward, 21 CF 2101. Judge, I'd like to leave her on March 30th without subpoenas. We're going to be looking into her score sheet as well as some other issues to see if we can get this resolved.
All right. Ma'am, they'll bring you back on March 30th. Akeem Dixon. Looks like he has 6 cases, is that right?
Your Honor, Tim Gibbs for Akeem Dixon, 6 case numbers, 22 CF 1506, 18 CF 2695, 19 CF 562, 19 CF 1659, 19 CF 1660, 20 CF 835. Judge, we're waiting on a response for applications for him for treatment options. I'd like to leave him set for March 30th.
All right, without objection, we'll leave him on the docket March 30th at 9 o'clock. Michael Duncan.
He's going to look for it. And he'll He probably won't, the investigator probably will. Your Honor, Tim Gibbs from Michael Duncan. Judge, he's on the docket this morning in 21 CF 2830. He's also on this afternoon's docket, Judge, of 23 CF 304 for arraignment. Judge, we'd like to enter pleas of not guilty as well as a VOP denial on these cases. If I could set him for March 30th, Judge, we're getting him referred to drug court as an option for him. And I believe we may be able to have that done by that date.
All right. We'll put him on the docket for March 30th at 9 a.m.
Thank you, Judge. So hopefully she'll come see you like tomorrow or Monday.
Cutter Ford.
Correct. Thank you.
No, he doesn't need to come back this afternoon.
No, we
Oh,
did
I
the
did.
not guilty,
Okay.
Judge. Thank you.
You Cutter Ford? Okay.
Your Honor, Tim Gibbs for Cutter Ford, 22 CF 1928. Judge, we're here for a motion to reinstate or set bond in Mr. Ford's case. He's been incarcerated, Judge, this most recent since August 10th, 2022. His bond was revoked in this case due to a new resisting without violence charge. That case has actually since been resolved. He is no longer being held on that charge. He was previously in the Okaloosa County Jail, Judge, from July 29th, 2022 to August 9th, 2022 on these charges. He's asking that his bond be reinstated or otherwise set to a signature bond with pretrial supervision. He is going to reside locally, Judge, with family. I know his family was trying to be here. They were having car trouble, so I may not be able to call them quite yet as witnesses, potentially, but they would be able to take him to appointments. He has previously been recommended to be found incompetent to proceed by Dr. Zeman. That was on an October 25th report. Due to intellectual disability, the court did order the Agency for Persons with Disabilities, APD, to evaluate Mr. Ford pursuant to statute. That order was signed November 1st. As far as I'm aware, I've not received any order. As far as I'm aware, he has not been evaluated by APD, and his family would be able to take him to appointments even as far as to Pensacola if necessary for evaluations with APD in order for them to evaluate whether or not he is competent to proceed. And he's been in the jail this whole time, and they haven't been able to they haven't gone to evaluate him, Judge. We're asking that his bond be reinstated.
He was, he made a bond on this case where he was charged with burglary of a dwelling and grand theft firearm, is that right?
That's correct, Judge.
And he was out on bond on that?
Correct. He made that bond. Then he got a new charge of resisting without violence. That's what the first appearance court at that time revoked the bond in this case. However, that resisting without violence charge has since been resolved. I do not believe he's even being held on that charge anymore in the jail.
All right.
I wouldn't object, Your Honor, to reinstate the previous bond.
All right, I'm going to, I'm looking at the, yeah, the last bond he was on was $10,000 for count one, $2,500 for count two. I'll go ahead and give him another bond, allow him the same bonds, $10,000, $2,500, counts one and two respectively.
Is that a new bond, Judge, or is that a reinstatement?
No, it's not a reinstatement because the bond was released.
Okay, he was. Okay,
It was
I missed
released
that.
according to the court docket. So I'm going to give him a new bond, those amounts.
And Your Honor, may I ask, because there are victims involved, that there is a no contact
Right,
and
it'll be,
No objection.
yeah, no contact with the alleged victim in the case, no, and not to be in a possession of any weapons of any kind.
Understood. Thank you, Judge.
Okay.
Do you have any questions?
Cameron Vance.
Yes, Your Honor, thank you. Your Honor, Tim Gibbs for Cameron Vance, 21 CF 1683, if I have just one moment.
score sheet.
I have it, thank you. And today's date, please, March 9th. All right, thank you very much. Your Honor, if I may approach with a written plea and a score sheet.
All right, sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? And you're Cameron Vance? And Mr. Vance, I have a written plea agreement. It's dated today. It has what appears to be your signature. Is that your signature?
Yes, sir.
And you understand, sir, that pursuant to the agreement, you'd be admitting the violation of probation. Your probation would be revoked and terminated, and you'd be sentenced to 140 days in the county jail. Is that what you want to do?
Yes, sir.
All right, the court's going to find that the written plea of, no, it doesn't say. How's he pleading?
No contest, Judge.
All right, the plea of no contest is freely, voluntarily, and intelligibly entered. After defendants have benefit advice of counsel, the court will accept the plea. He'll be adjudicated guilty of the violation of probation. I'm going to revoke and terminate his probation. He'll be sentenced to 140 days in the county jail. He'll get credit for all time served. He'll be required to pay $100 cost of prosecution, $150 public defender fee, and that'll be payable within 180 days, failing in which it'll be reduced to judgment lien that'll accrue interest at the legal rate. So you have a right to appeal the legality sentence of the court. If you can't afford an attorney and want to be appointed, you have 30 days from today to file your notice of appeal.
Yes, sir.
Good luck to you, sir.
I'm sorry? So yeah, the 140, the jail calculates the game time. Yeah. If you have any questions about the credit, let me know.
Yes, sir. Thank you.
I believe that concludes my business this morning, Your Honor.
Okay, then we go to Ms. Rivers. And first case we have is Donald Robinson, is that right?
Yes, Your Honor. We had filed a motion for bond. He has since made bond, so I would just request to put it on the 424 docket.
All right. Hopefully they told them that when they released him, but we'll put it on for April 24th docket, May 1st docket day with May 8th jury selection.
Yes, sir.
Bobby Simmons.
Your Honor, in speaking with the state, there's something that we're trying to work out, so we're requesting that it be put on for the 30th, March 30th.
All right, we'll set Mr. Simmons' case March 30th at 9 a.m.
Ms. Rivers, do you want to
Jail.
arraign him on his new case?
Your Honor, he does have a case for this afternoon. That is 23 CF 317. And we're going to tender a not guilty plea at this time. Request that he have a trial by jury in time to file any pretrial motions if necessary.
And we can track this case along on the March 30th date with the other cases as well, Judge.
Okay, we'll put it on for the April 24th docket, May 1st and May 8th at 9 a.m.
Yeah, you just going back.
Donald Simmons.
Your Honor, I previously met with Mr. Simmons. He gave me a list of people for reciprocal discovery that we're trying to get addresses for. So at this time, we are going to request a continuance in this matter. I would ask to put it, he has a new law, so you have a new law, right? I would ask to put it on the 424 docket.
All right, any objection?
No objection.
All right, April 24th, pretrial, May 1st docket day, May 8th jury selection, 9 a.m.
Years.
That's the alternative offer.
2 years prison? Okay, so you're ready to do the 2 years prison?
Yeah, I'm ready.
So if we could put them on for this afternoon, Your Honor?
Okay.
Okay. I'll write it up and we'll get you done this afternoon. got the numbers? Thank you.
I got six.
That's your auntie's number?
Auntie Pam, her name is Pam.
Okay. Your Honor, before the court is Monica Simmons on 19 CF 1523 and 20 CF 1854. I have met with her several times three times to see where we're at, because she's been back and forth to the Florida State Hospital, and based on two of the three visits, I feel it's appropriate at this point for Dr. Zeman to come in to conduct an evaluation to make sure that she can go forward on her cases.
All right, so you want to pass it and have her-
Continuance, yes, Your
and
Honor.
have her evaluated?
Yes, Your Honor.
All right, we'll pass it to April 24th at 9 a.m.
And if so, then we'll see about doing that, okay? I just got to make sure that you understand everything.
The drug classes off.
Okay, and I'll talk to her about that.
Okay, thank you.
Mm-hmm.
Folks, do y'all have a case? What's his name?
His name is Chance Stapleton, Your Honor. This morning, we were scheduled to have a immunity hearing. Ms. Basso is in trial in the South End. She's requested that it be reset. We discussed the date of resetting the immunity hearing to 5/6. And so we would have docket day on 4/24, but the contested hearing would be on 5/6. May 6th.
On May the 6th?
Yes, Your Honor.
All right, well, let's put it on for April 24th. I don't see May 6th on the docket sheet.
It might have been, okay.
Was it May 4th per chance?
It might have been. We could do May 4th.
I don't see May.
Yes,
Is May
it
6th
could be.
a date? No?
And it might have been April 6th that I got confused when I
Oh,
was looking at.
April 6th?
It might have been April 6th. And I'll just, let's put it on for April 6th, and I'll just verify, and if she can't do it, then we'll reset it.
All right, sir, we're going to set your immunity hearing for April the 6th. That'd be at 9 a.m. Okay?
Okay.
Who's next? Anita Smith?
Yes, Your Honor. The last information we have is that she was in Bay County, at the Bay County Jail. We don't have anything further.
We looked last time, and the public defender was appointed to determine that. I don't have any information that she's still in the jail. So, my notes from February 28th says that the defendant isn't here, judge will issue capias.
Was a capias issued for her?
Not on the 28th. We reset it for March 9th to confirm if she's incarcerated anywhere.
And we don't know.
Your Honor, the case that I was asked to check on, I did check on. We did confirm she was in jail. I'm just not remembering that this was the person. That she was in Bay County Jail, but as for is she currently still in as of today, I have no information.
All right,
Your
well, I'm
Honor.
going to issue a capias for her. That'll serve as a hold on her anyway. Issue a capias for her arrest, failure to appear, no bond pending first appearance. And when they get her here, if it turns out she was in jail, I'm sure the judge will.
Probation already researched that for us.
Yeah.
I mean, is this her?
That's the picture of my phone. She is in fact in Bay County Jail. They've just
Okay.
confirmed it.
All right, we'll go ahead and issue it anyway. It'll act as a hold on her. And then when you get here, they can address a bond. Hakeem Smith.
Your Honor, we've reached an agreement in this matter, if I may approach.
Okay. Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Smith, you're Hakeem Smith, is that right?
Yes.
All right, Mr. Smith, your attorney's just handed me a written plea agreement. It's dated, looks like March the 7th, has what appears to be your signature. Is that your signature?
Yes.
And prior to signing this, did you read it? Did your attorney go over it with you?
Yes.
Do you understand it?
Yes.
This is your original charge. This is the printout. That's not what
Oh,
you're
okay.
pleading to, because she's getting rid of that count right there. Remember, I have it highlighted in yellow.
I was wondering what's going on.
Yeah.
All right, well, let me understand what it says here so we can go over it with him. He's going to be pleading to what? The possession of firearm by a convicted felon or to count 2?
No, Your Honor, he's going to be pleading to possession of firearm by a convicted felon. The state's dismissing count 2.
Okay, that's what wasn't clear to me.
And then there was also count 3 and count 4.
And the state for count 1 is removing the 10/20 life.
Pardon me?
The state for count 1 is removing the 10/20 life
Okay.
requirement as a lesser included.
All right, do you understand, sir, that by entering this plea this morning, you'd be sentenced to 12.25 months Department of Corrections at state prison, and the state is removing the mandatory 10/25 life from it, but you would be spending 12.25 months state prison. Do you understand that?
Yes.
You understand that you're waiving your right to trial by jury?
Yes.
And are you satisfied with the services of Ms. Rivers, your attorney?
Yes.
And have you had a chance to discuss this with her thoroughly? All right. Have you had anything to drink in the last 24 hours?
Water.
That's okay. Water's okay. And I know it sounds funny, being in jail, and I ask that question because you never know, but you haven't had any drugs in the last 24 hours, have you? All right. So what you tell me is you're entering this plea freely and voluntarily of your own will. Is that right? Okay. All right. And he's pleading no contendere to counts 1, 3, and 4 then.
That's correct.
All right. The court's going to find that the pleas of no contendere, count 1, possession of firearm by convicted felon, count 3, third violation of an injunction against domestic violence, and count 4, violation of that injunction is freely, voluntarily, intelligently entered. After the defendant's had the benefit advice of counsel, the court will accept the plea and adjudicate him guilty of those 3 offenses. On count 1, he'll be sentenced to 12.25 months state prison and remanded to the custody of the Department of Corrections. He'll be required to, he'll get credit for time served. He'll be required to pay $415 court cost, $100 cost of prosecution, $150 public defender fee. And then on cases or counts 3 and 4, he'll be, on count 3, he'll be sentenced to 12.25 months concurrent, no other conditions. And count 4, he'll be sentenced to time served. And what's the state going to do with count 2?
State announces a null pros to count 2.
All right, sir, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed
No
for you. You have
pros.
30 days from today to
It's
file your
dismissed.
notice of appeal, and you will need to be fingerprinted on this charge.
And, Your Honor, that was removing the 10/20 life on
Without the 10/20 life.
on the count 1, so there's no mandatory minimum.
Correct.
You're good.
All right, thank you.
Uh-huh.
Oh, wait, did I already have the jail list?
Your Honor, if I may have a moment, we did speak just do you know?
Yes, she has the list.
Your Honor, there was a counter offer made. The state had rejected it, so I was just conveying that to him.
So she wouldn't give me like any more of my credit for time served.
She's just willing to do it to that July date. Do it? Okay. If I may approach, Your Honor.
All right. Sir, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. What is your name, sir?
Gregory Spears.
And Mr. Spears, I have a written plea agreement. It's dated February the 10th, has what appears to be your signature. Is that your signature, sir?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir.
Did you understand it?
Yes, sir.
Did you go over it with your attorney?
Yes, sir.
Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning?
No, sir.
Are you satisfied you've had sufficient time to discuss the case, any theories of defense of the charge with your attorney? And are you satisfied with the services of your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
Sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
All right. And has he pleading?
No contest, Your
All right,
Honor.
I'm going to indicate that on here, and I'll initial it. All right, the court's going to find then that the plea of no contest, case number 2012-1016 and 2012-1224, they're both VOP cases, is freely, voluntarily, intelligently entered after defendants had the benefit of advice of counsel. The court will accept the plea. He'll be adjudicated guilty on both. And it's going to be a judgment sentence to the court that he be reinstated on his original probation on both cases with the following special condition. He'll be required to serve 11 months, 29 days in the Okaloosa County Jail with credit from July the 10th of 2022. He'll be required to undergo a substance abuse evaluation and complete any recommended treatment, and he's not to possess or use illegal drugs or controlled substances without a valid doctor's prescription, and he'll be subject to random urinalysis. He'll be required to make a good faith effort to obtain a valid driver's license, and the court will continue to waive cost of supervision on the probation. I will assess a $100 cost of prosecution on both cases, $100 public defender fee on both cases, and $50 and a one-time $50 public defender application fee, and that's going to be assessed on case number 2012-1224. Sir, you have a right to appeal the legality of sentence of the court. If you can't afford an attorney, one will be appointed for you for that purpose. You have 30 days to file your notice of appeal. This is a downward departure based upon a legitimate, uncoerced plea agreement. And you will need to be fingerprinted on that, sir. Good luck to you.
The next one would be Ashton Tobias. Your Honor, we've reached an agreement in this matter, if I may approach.
Yes, ma'am. Ms. Tobias, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir. Your Honor, the state had written that there was to be intensive outpatient treatment. They're no longer doing intensive outpatient treatment, and probation confirmed that, and Ms. Leon did confirm with the state attorney, and that part was being marked off. You have to do treatment. They just no longer offer intensive.
Okay, got you.
All right, Ms. Tobias, your attorney's handed me a written plea agreement. It's dated yesterday, has what appears to be your signature. Is that your signature?
Yes, sir.
And prior to signing this, did you read it?
Yes, sir, I
Did
did.
you understand it?
Yes, sir.
Did you go over with your attorney?
Mm-hmm.
Did she satisfactorily explain the terms and conditions of the written plea to you?
Yes, sir.
Do you have any questions concerning it this morning? Are you satisfied you've had sufficient time to discuss the case and any theories of defense to charge with your attorney?
Yes, sir.
And are you satisfied with the services of Ms. Rivers, your attorney?
Yes, sir.
Has anybody forced, coerced, or threatened you to sign this written plea?
No, sir.
Have you had any drugs or alcohol within the last 24 hours?
No, sir.
All right, the court's going to accept the admission to the violation of probation, case number 20 CF 719, find to be freely, voluntarily, intelligently entered after the defendant's had benefit advice of counsel. She'll be adjudicated guilty of the violation, and I'm going to place her on a new term. Her old probation will be revoked and placing her on a new term of supervision. That's to be 1 year community control. She'll be required to have a substance abuse evaluation and complete any recommended counseling, and she may have already done that, but if she has, she needs to furnish proof of it. She's not to be in the possession of or use illegal drugs or controlled substances without a valid doctor's prescription. She'll be subject to random drug testing, complete any previously imposed conditions of probation, and she'll I'm going to waive the cost of supervision. She'll be required to pay $100 cost of prosecution, $150 public defender fees. Ma'am, you have a right to appeal the legality sense of the court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal, and you will need to be fingerprinted.
Your Honor, the next one was Tyrone White, but we dealt with him first thing this morning, so the next one would be Richard Whitfield. Mr. Whitfield is before the court on 20 CF 2835, 20 CF 2859, 20 CF 2887, 21 CF 443, 21 CF 446. We are requesting a continuance at this time.
What were you requesting?
A continuance.
Okay. Without objection, April 24th, 9 a.m., May 1st, and May 8th, respectively, at 9 a.m. for docket day and jury selection.
Are all these VOPs? Are all his cases? Judge, these are all VOP cases. April 24th is our pretrial. Is there any way we could put it on the miscellaneous VOP docket that week?
What date is that?
Looks like we have
Not
April 27th
yet.
is a miscellaneous.
Okay, we
Okay.
can do that, April 27th.
I didn't realize these were all VOPs until.
April
That works.
27th at 9 o'clock for all his cases.
Yes, Your Honor.
This Dustin Williams? Are you Dustin Williams? Okay.
Yes, sir, I sure am. Yes, sir, it's me.
Okay, thank you, sir.
And Your Honor, we are going to request a continuance to 3:30 at this time.
No objection.
All right, we'll set it for March 30th at 9 a.m. We'll see you back on that date, sir.
Where do I
Jeffrey
sign?
Willis.
How many days I get? Where do I sign?
I'll come out there. I'll come out there and see him. Okay. Yep, yep. Didn't he mention that? Your Honor, this is Mr. Jeffrey Willis on 22 CF 1565. We're here for a status call. The last, time before last, when we were in court, Dr. Harper was supposed to be doing an evaluation to determine his competency. I believe she has, in fact, done the evaluation. My client has indicated she's done the evaluation. We're just waiting at this point on a report so we can see how to proceed.
I don't see a report docketed.
And I don't have one either, Your Honor.
April 24th.
Did
April
you-
24th, Judge, pretrial.
Okay. All right, we'll pass it to April 24th, pretrial.
And if they don't have the report, then we'll see about waiving your appearance for that one, okay?
Thank you.
Brings us to Bailey Wilson.
I'm not sure why she's not present. She was here in court last time.
When was last time?
For her VOP plea day, her VOP arraignment.
Have you had any contact with her? None? All right, issue Bailey Wilson. There's no one in the courtroom, so she's obviously failed to appear. Issue a capias for her arrest, failure to appear, no bond pending first appearance. I think that takes care of the morning docket, does it not?
Your Honor, would you like for me to send a written order on Ms. Chancey's case so that she can be released?